Thank you everyone so much for being here this evening. I know it's not a big crowd, and I think that's because extreme risk protection orders sound a little bit technical, right? And they are a little bit technical, but as we're going to learn tonight, they are a super important way to help address gun violence in our community. I wanted to open with just telling us a little bit about setting the landscape, a little bit about what gun violence looks like in Minnesota right now before we dive in. And to that end, I just wanted to tell you that last year in Minnesota, there were 572 deaths from gun violence, which is pretty remarkable. It's up 20% from 2019, and it's up 6% from last year alone, at a time when gun violence is down 5% around the rest of the country. So we know that here in Minnesota, we're facing some pretty unique challenges. We've seen that this year with the assassination of Melissa Hortman and the shooting of John Hoffman. We've seen it with the Annunciation mass shooting, with the shooting of 11-year-old Amir Atkins here in Minnesota, and so many more deaths that have gone unreported or haven't gotten as much attention. And a lot of times when I do these kind of speaking engagements, we get questions. I get a specific question, which is like, yeah, that's all good. Like, we should change legislation, and we should do this, and we should do that, but I want to know what I can do right now to help end gun violence in my community. What's something that I can do in this immediate moment to help end gun violence? And extreme risk protection orders, knowing about them, knowing what they are, using them if you ever have the need to, and making sure everyone else in your community knows how to use them, is the thing that you can do right now to help prevent gun violence in Minnesota. So with that, I'm going to hand it over to our trainers this evening. Thank you so much for being here. And I just want to say that Senator Bonnie Westland just walked in, and she's been a huge champion for us, so round of applause. She really helped get this legislation over the finish line, so thank you for being here.
Good evening, everybody. Thank you so much for being here. I'm Rana Alexander. I am an assistant county attorney with the Hennepin County Attorney's Office. A little bit about me. I was hired by the County Attorney's Office in June of 2024 to kind of manage our office's response to the Extreme Risk Protection Order statute that was passed and came into law in January of 2024. So my job is I provide training and technical assistance not only within our own office, but to all of our community partners across Hennepin County. So it means I come and I do things like this, or I answer phone calls from law enforcement, or I talk to mental health professionals. So I try to help all the people who might be touching this statute and help them figure out how we can use it in a way that can be helpful and safe for our community. And then in May, we hired Bridget.
Yes. So my name is Bridget Liverca. As Rana said, I started in May. I am not an attorney. I like to joke about that. I'm very much not an attorney. But my title is a legal service specialist, so that's kind of the attorney office way of saying advocate. So in addition to doing trainings like this, my main role is to work at the Domestic Abuse Service Center, and I assist family and household members deciding if it is right for them to file an extreme risk protection order. In addition to that role, my background, I worked 17 years in disability services. And so part of that is to do maybe a little short-term follow-along safety planning for someone if they are filing on behalf of someone who is struggling with their mental health. So making sure they have access to services outside of, just doing the extreme risk protection order.
So we're going to talk about, well, first of all, some kind of background about extreme risk protection orders, and I'm going to go into kind of the minutia about extreme risk protection orders, hopefully not too far into it, because you guys probably don't need to know all that really in-depth stuff, and then we're going to talk about some other things that are helpful to know for folks. Extreme risk protection orders, or I refer to them as ERPOs. Everybody else calls them ERPOs. I just don't like the word ERPO. It sounds gross in my mouth. So, you know how everybody has those words? And that's one of my words. And it's funny because now it's part of my job. I say ERPOs. Other folks might have heard these called red flag laws. So you might have heard through, like, the media often talks about them as red flag laws. So, but in Minnesota, we call our red flag law extreme risk protection orders. All right. So you got to remember.
Yeah.
Okay.
All right, so we'll start with a little bit of background on how we got here. So there, from 2023, there's 525 gun deaths in Minnesota. 81 of those were children and teens, so ages 1 to 17. On average, one person is killed every 17 hours in Minnesota. Firearms are used in the majority of homicides, so 65% are homicides and 47% are suicides. Domestic violence homicides were a total of 27, and as you can see, like 16 of those were from gunshot wounds. So by the numbers, access to a gun makes it 5 times more likely that a woman will die at the hands of a domestic abuser. Nearly 6 million women reported having a gun used on them by an intimate partner. In nearly half of mass shootings with 4 or more people killed, the perpetrator shot an intimate partner or a family member. Each year, an average at least 1 in 8 prohibited gun purchases denied by a background check are denied due to prohibiting domestic violence.
Yeah, those
Yes.
sets were
Yeah.
national.
So 16% fewer intimate partner gun homicides. So laws requiring people who have abused their partners to turn in their guns are linked to 16% fewer intimate partner gun homicides. So how and why ERPOs were developed. The first group convening in March of 2013, so this was after Sandy Hook, to identify new practices and policies based on research. So they determined they wanted to use a civil process to temporarily remove firearms. So this is a really big and important sentence to use, especially, since we're doing a training here, when you're out in the community talking to your neighbors, talking to whomever, making sure we're using the word civil process and temporary. This isn't criminal. This isn't permanent. Some people might do something to make it permanent, but this law in itself is not permanent. So when they are in a clear threat to themselves or others, so again, like coming from a cause of concern. It gives judges a clear legal authority to order firearm removal, and also gives law enforcement clear and legal authority to remove firearms. And then, like I said before, it developed the policy following that meeting. So, as I said, they are civil orders. They were modeled off orders for protection. They are civil orders with criminal repercussions. ERPOs enjoin and prohibit the respondent temporarily from possessing or purchasing firearms. It creates a formal process for the respondent to depossess themselves of their firearms either by voluntary compliance or through a search warrant. This is unlike orders for protection. So when someone is experiencing domestic violence and they go file an order for protection, the respondent has to comply and give their firearms away, but it does not get them that search warrant. It flags the respondent in NICS, so that's the National Background System, to prevent firearm purchases. And then there's 2 types of extreme risk protection orders: the emergency that lasts for 2 weeks, and then long-term orders that last 6 months to a year. Just an overview. So California passed the first modern day extreme risk law called a gun violence restraining order. They use GVRO in 2014. We passed our law in 2023 and it became effective January 1, 2024. As of October 2025, 21 states, DC, and the Virgin Islands have ERPO laws. So ERPOs can be used in a variety of circumstances. So threats to self, they can also be, combined with threats to self or others together. So, sometimes we see domestic violence where they're going to hurt themselves, threatening to hurt themselves, threatening to hurt their partner or other household member, and then just threats to others. So domestic violence, workplace violence, school shootings, and then community violence. So this is where extreme risk protection orders and orders for protection intertwine, and then we'll talk about the differences as well. So for extreme risk protection orders, the petitioners include law enforcement and family members. The respondent is a significant danger to themselves or others with a firearm specifically. The sole relief is prohibiting the respondent from possessing or purchasing firearms. It creates a legal process to remove firearms with a search warrant. Both are civil orders. Both are the violation of these orders is a crime. They're both time limited, and the court process is similar. So what I do sometimes also is at the Domestic Abuse Service Center, if someone is experiencing domestic violence, often they can meet with me, and I could do order of protection and an ERPO, or they can meet with another advocate, and we try and do them at the same time and submit to district court at the same time, just to help ease that court process as well, because sometimes they can get their hearings at the same time and day. So the order for protection, the petitioners are family or household members only, so law enforcement cannot file. Respondent has committed domestic abuse. The relief is focused on domestic abuse. After a hearing, the respondent is prohibited from possessing or purchasing firearms. And then, like I said before, the firearm removal is based on voluntary compliance. So research to date, ERPOs have been used in response to threats of suicide and interpersonal violence, including mass shootings. Most petitioners are law enforcement. Implementation varies greatly within and among states. Local champions are critical to implementation uptake. So 1 life is saved for every 10 to 20 firearm removals. So our office's response, the new position was created, Rana, our attorney, to do training and technical assistance. I was created as an advocate. Like I said, I direct advocacy to family and household members for applying, and then I also help training and technical assistance. And so part of the reason we're here, and at the end of this PowerPoint, we'll go over like how to reach out to me, how to make referrals, and then how else we can help as well.
All right. So we're going to talk about the statute. Does anybody have any questions about the statistical background? Bonnie? Mm-hmm.
Family members and law enforcement. Are there other states that have more expansive list of people who can file this?
Who can petition? Yes. Some states allow mental health professionals to petition. Some states allow school professionals to petition. My understanding is that it basically never happens for a couple of different reasons. A, for a mental health professional to petition, now we've got a confidentiality issue. Also, it's a legal process, and people are really angsty about getting involved in a legal process, just generically, right? It's a big deal to get involved. And so they have found that my understanding is it's extremely rare in those states that allow that for folks to file. So, yeah.
So I practice that.
I know. I know you do.
One of the big problems with the OFP is the voluntary component.
Yeah.
And so I would love to hear some ideas online about tightening that up.
Yeah.
Because I have had situations where the cops won't go through.
Right. Yep.
Even though we have an order that says they can't have.
Yeah. Yeah.
They literally won't go do anything about it. And part of the problem is they don't have anywhere to store the firearms. It's liability.
Yep.
Whatever.
Whatever.
So if you have some ideas, I would like to tighten that up. Because it's
Yeah.
a huge problem.
Yeah, I absolutely agree with you. And oh, I'm so sorry, you guys. Yeah. Yes.
Oh, I have a
I'm so
microphone.
sorry. I thought, that's my bad. She was saying how she want to have a conversation offline about, is there a way we can tighten up? That's a really good point. Is there a way that we can tighten up orders for protection so that there can be some follow through when there are firearm prohibitions that will allow law enforcement to maybe go and take firearms similarly? So, and I said, yes, I have some ideas. There are some states that are doing some things around that, and I think we could also get some technical assistance from some of our national folks on helping us with that. So yeah, it's definitely been a piece of conversation. Yeah. Get you a microphone so We don't require.
What is the process for an ERPO?
We're going to talk.
Like-
We're going to talk about that.
Okay.
Yeah.
All right.
Excellent. I appreciate that. You just set me up perfectly. I think there's a question over there.
Oh, he's.
Hey, so I'm a pediatrician. Love the healthcare provider idea. I think that's a really cool one. One thing that makes me wonder is we, healthcare providers, one of the few times we're willing to grapple with the law is in the context of child protection. As flawed as that system is, it is a place where people land when there is intimate partner violence or family violence. In any of these states, is child protection involved, and is child protection able to be one of the initiators of this?
Child protection is not able to initiate. However, child protection specifically, but child protection is always represented by a county attorney or a city attorney, or the county attorneys. The county attorneys can file. And then in the other states, it was, is child protection ever involved? And if I have seen in case law, because that's about my closest glimpse in these things, is that there have been times where child protection, if we have a minor and an order and an ERPO is being filed on behalf of a minor, that sometimes child protection is involved.
Okay. Yeah. Cool. And then I'm noticing you're both from Hennepin County, which is great because I'm in Hennepin County. Love that. Yeah. What about Ramsey and the rest of the counties in the state? And in rural Minnesota, this is still an issue. Is there a similar infrastructure in other counties, or are we kind of leading the way?
We are leading the way. A piece of it is, Hennepin's bigger, so there is the ability to have a full-time 2 positions to do this work, right? If you're over in Cook County, where Grand Marais is, there's only 6,000 people in the whole county. So, but other counties like Ramsey County has somebody who is similar to me. Her name is Dawn Bask, and she does this kind of coordination in addition to some other things. And then we have a number of city attorneys who are helping their law enforcement be able to file and are doing a lot of that kind of work. And so their training and technical assistance is really based on helping their law enforcement departments that they support be able to file. And then a number of our counties, even outstate, have protocol or process. Interestingly enough, the first county that filed an ERPO was Martin County. Most people don't know where Martin is, very tiny county.
So since the start of this is been here now for a few years, ERPO. So how many cases have so far been reported? How many petitions have been filed? And if there is a small number, is it because lack of awareness or less crime?
Yeah, that's a really good question. So how many have been filed? So last year, I believe we had 29 filed in Hennepin County. And then this year, so 72 have been filed so far this year. 73 is supposed to be filed in the morning. So we've already almost tripled. And so I think that that's a pretty great outcome. And I don't know, Maggie, if you remember the numbers for the state. I know we just got them the other day, and I've already forgotten them.
So statewide, last year there were just over 140 filed all around the state throughout the year. This year it's already been 258 as of last Wednesday. So we've seen a significant uptick this year over last year statewide as well.
Yeah. Yes.
Is it happening just like because of the awareness? It is you're finding more, or is like the incidents have increased, or just the awareness has increased and you are seeing more?
I think it's that awareness has increased, and we are seeing more. And I think also law enforcement's becoming more and more and more comfortable, and they're like, oh, well, my city next to me filed one. Okay, I can do this, right? And so I don't think it's a reflection of that more crazy things are happening. I think it's a reflection of just more people are aware and are filing.
Can a teenager file for an ERPO? Like can a teenager call the police or somebody to say, I need an ERPO?
A teenager could certainly call the police and say that they need an ERPO. I think on filing on their own, normally minors are not able to file legal actions on their own. So I would say no.
We haven't had it happen, so maybe, yeah. I would just more
I mean,
suggest
when I
law
look at
enforcement doing.
when I look at like the harassment restraining order statute, which has specific language allowing, or the order protection statute that has specific language allowing minors to apply in certain circumstances, that makes me think that since we don't have any language at all, the legislature knows how to write language. And they have chosen not to, so I would feel like, sorry, lawyer. So my guess is no. It wouldn't necessarily stop me from trying, depending on the circumstances.
While we're on the subject of awareness, are you tracking how people are coming to you for an ERPO?
Yes.
Because, I mean, that's the biggest, we're talking about that. That's the biggest reason why probably more applications are being filed, because people are learning about them and knowing that this tool is available. So wondering if you're tracking how people are coming to you, and also what is your marketing plan? Because, I mean, it sounds crazy to talk about marketing when it comes to ERPOs, but it's probably the most important. Somebody's got to be doing it, because this is an amazing tool, and if people don't know about it, and it's people like us.
Yeah.
I mean, I know law enforcement is covered, although a lot more work needs to be done there, but it's people like us. So how do you plan on spreading the word?
Yep. We've got a variety of things that we are working on. It's actually very funny. When I used to work for a nonprofit for 19 years, and we were a very small nonprofit, and I did all the things, right? I wrote our website, I paid our bills, I did all the things. And I joked when I left that I was never going to have to update Hennepin County's website. Isn't that great? And now I'm frustrated because all I want to do is go update their website so that I can. So we are working on it, on getting our own website, our webpage through Hennepin County. In addition, and the statewide level, the Department of Public Safety there's a position that they are hiring as a statewide coordinator, and that person, a big piece of their job, will be doing all this kind of outreach, like that kind of stuff. Bridget and I are working on magnets for mental health professionals to remind them that, ERPOs are a thing, right? Because it's a thing that they'll probably maybe do twice in their entire career. So it's to help them to remember it's a thing and to remember. So we're trying a bunch of different weird things to figure out how to get the word out. I don't know if you saw last month, the county attorney's office did actually a huge push on their social media about ERPOs. We have our toolkit that was out there. We did the little videos of us, and so but yes, I hear you.
And also, we had a gun violence prevention task force that met twice, and Senator Latz actually is talking about trying to find some funding that would go into a public education campaign. I think when you get into greater Minnesota, there are two issues. One is there's probably less awareness, and second issue is more of some counties may have officials who just under no circumstances will ever file an ERPO.
Yeah.
Sorry, I said ERPO.
No.
It's all right. Other people can say it. It's just not coming out of my mouth.
I think before I ask the question, I think this is also kind of an attempt to market, because what we did is we sent emails to different mosques and synagogues and different worship places, because they are also leading big groups. So they need, I think, if you go to these places of different faiths, you can still create more awareness in their kind of educational programs. So it becomes it can spread faster. Because in politics, everything becomes done politics. We only wake up every 4 years when there is a major elections. Otherwise, nobody's looking into much. But coming to my question was, compared to this ERPO and FPO, one seems to be slightly more focused, more domestic and more after matter of fact when the act has happened. And ERPO is more seems to be more proactive. You can, without anything happening, you can report something. So what kind of evidence is considered as valid for someone to take action? Because there are gray areas. How is it planned in how the law is written that there are less chances of someone just getting off without before we can put our handles on. So is it like very clear in terms of like laws that when someone files a petition, they know that if these 3-4 points are there, then it will definitely, they will get some order of kind of taking the arms away?
Yeah, that's a really good question. And I'm actually, that sets me up here. So let me talk about the statute here, and that will give us some information. Sorry. Okay. All right. So the statute tells us that there are 9 things that the court can consider. It does go on to say in the statute, it says that the court can also consider anything that would help the court decide on whether or not to grant the ERPO. So statute talks about history of threats or acts of violence towards other folks, history or attempted use, threatened use of physical force, violations of any court orders, including but not limited to violating other extremist protection orders, violating 260C orders, violating an order for protection, prior arrests for violent felonies, convictions or prior arrests for violent misdemeanor offenses, stalking or domestic assault, conviction of offensive cruelty to animals, unlawful and reckless use, display, brandishing of a firearm, suicide attempts or serious mental health, or being named in an existing ERPO 260C order or an order for protection. So things that are not listed here that, again, I always say fall under that anything else. I would include violations of harassment restraining orders or other harassment restraining orders. Definitely when I have been involved in these, we've had a number of cases where we have respondents who have lots of harassment restraining orders against them. The other thing that's not listed here that I would include is if there's a pretty significant substance abuse issue, right? If somebody is has a firearm and they're also a heavy meth user, that like adds some context to the court on why we might be afraid. Right? It also can help the court understand that, if you say, somebody all of a sudden they're 40 years old and they're having hallucinations, pretty significant hallucinations, that would be unusual for a 40-year-old to all of a sudden, mental health-wise, to start having hallucinations. But if the court now understands that, again, they're a heavy meth user, now all that makes sense. Like it comes together and it forms that story for the court to understand what's happening. And I do know we had the one where it wasn't necessarily cruelty to animals, but they were shooting squirrels in their backyard in front of the kids in the city limits. So we definitely included that. But these are things that the court can consider to decide whether or not it makes sense to issue that order.
Nowadays, we see the indicators mostly come through social media in many mass shootings also. We see what the person is posting on the Facebook or on other social media platforms, showing I want to kill someone, I want to do this. So is it like these rules were made before those things were a threat? Because right now that's so important. So is it included or it may get included?
Yeah, no, that's a really good point. And you're right, it really isn't well represented in the factors to consider. But yes, absolutely. And we've had a case like that where we had somebody who was posting on we've actually a couple of them, where somebody's posting on social media, making scary statements involving firearms, right? Or they're showing their firearms, or they're talking about getting firearms and doing something scary. Absolutely. That will definitely, having that clear information definitely can trigger an ERPO, for sure. Good point, thank you. So who can petition? In Minnesota, our statute allows law enforcement to petition the city or county attorney's office, a guardian of the respondent, or a family or household member. And so the definition of family and household member for an ERPO is significantly narrower than it is when we think about it in an order for protection petitioner. And so I point that out as somebody, my work before for actually 28 years, I've been working in domestic and sexual violence, so it was one of the things that was noticeable to me. So it includes spouses and former spouses, parents and kids, people who presently reside together, and folks who are involved in a significant romantic or sexual relationship. The order for protection statute in their family and household member definition includes things like related by blood or people who've resided together, folks with a kid in common, or people with a pregnancy in common. Those are not included currently in our definition of family or household member in the ERPO statute. I will tell you that I've got legislation that would expand it to the definition. Because what we see, there's a couple of things, is we see people who were in domestic violence relationships who aren't together anymore, and there's still very stalking, scary, icky behavior going on, but they don't qualify to apply. The other thing that we see is we have aunties and grandmas, and the ways that family is made up doesn't always just go parents and kids. And so we're preventing here, we're not, grandma or an auntie is going to have to reach out to law enforcement. Now, if somebody doesn't fall under those definitions right now that we have under our statute as family or household member, law enforcement is the best place to reach out to and to see if they will help. So the extreme risk protection order process is a two-part process, and if you happen to be familiar with the order for protection process, it will look exactly the same. It'll feel super the same, okay? But if you're not familiar with it, so there are two types of orders that kind of come along with this process. One can apply either on an emergency, what's called ex parte, and that means without notice to the other party. I always joke that Latin is the lawyer protection language because everybody else hears Latin and they get really nervous and scared, and so they go hire a lawyer. And it's why we keep using Latin, so that everybody gets nervous and scared and hires us. But it just means that we're not giving notice to the other party at first. And the reason is we talk about in the law as extraordinary relief. And so it means you have to show that something is really, 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 really scary right now, to be able to get that emergency order. And that's why we're not giving notice to the other party, because we need it right now. We don't have time to go through the notice part, because if we do, that would be really dangerous. So there's no hearing that's held at this point. So you fill out the petition, it gets sent to the court. There's no hearing that's held. The petition goes in front of the judge, and the judge is going to read the petition and decide based on the petition whether or not to grant that initial emergency order. At that point, when filling out the petition, the petitioner can ask for a long-term order also, but they don't have to. They could say, we just need that 14-day order. That's all I need. And there have been certain circumstances where that makes sense. The vast majority of folks are looking for that longer-term order. If no hearing is requested, that order is going to expire in 14 days. If the court makes a finding when looking at that petition that there is probable cause to believe the respondent possesses a firearm, and there's been enough information given to the court about where those firearms are, then the court is going to can issue a warrant, or will issue a warrant to take possession of those firearms. The respondent has the opportunity to voluntarily comply prior to execution of that warrant, but it will allow that opportunity for that warrant, which is one of the big differences between ERPOs and orders for protection. Then there's that long-term order, and if somebody would like, if they apply for it through that ex parte process, they will have a hearing within 14 days. What's happening in Hennepin County is sometimes we're getting hearings really, really fast. I filed for one on Friday, and I had a hearing yesterday. And I was just like, wow. And then the court wanted to have the evidentiary hearing in like a week. And I was like, I don't know if I can subpoena my deputy that fast. But the court has to have a hearing within 14 days. So you get the short term, the one that lasts for 14 days max, and then you can apply. And then you can also get that longer term one, and that can last for up to a year. If somebody's looking for that longer term order and there is a hearing, here in Hennepin County, the way our courts handle it is we allow what we do, we call it bifurcating, where we have an initial hearing where the respondent lets the court know, would you agree to the issuance of this extreme risk protection order, or do you want an evidentiary hearing? And whatever you want to do is great, but we're just wondering, because if you're willing to agree, then that's great. And then we don't have to call all the witnesses and go through all the things, right? But sometimes respondents do want that evidentiary hearing, and if they do, then after an evidentiary hearing, the court would have to decide by clear and convincing evidence that the respondent is a significant danger to other persons or is a significant risk of suicide by possessing a firearm. Clear and convincing evidence is a higher standard than your typical civil standard, which is preponderance of the evidence, but it is still lower than a criminal standard of beyond a reasonable doubt. Evidence professors would get mad when you put percentages to them, but I always think about clear and convincing as like 75%. You feel 75% sure that that's what happened here. And as I said, the statute tells us actually that the order cannot be less than 6 months, but it can't be more than a year. And there is an opportunity for extension if the person is still exhibiting concerning behavior. So the statute has a requirement around transferring of firearms, and unlike the order for protection process, which allows the respondent to transfer their firearms to pretty much anybody who's willing to take them, the ERPO process is very specific. So the respondent does have the opportunity they get to choose whether they want to transfer those firearms permanently or temporarily, and that is up to the respondent, totally get to choose. Almost everybody goes with the temporary option. And if there was not a warrant, then they need to, as soon as reasonably practical, but no less than 24 hours later, they got to transfer those firearms to either a federally licensed firearm dealer, otherwise called an FFL, and that person can charge a reasonable fee, or they can transfer it to law enforcement. And law enforcement has to accept the transfer, and they are not allowed to charge any fees. So everybody that I know who's transferred firearms has done so to law enforcement so that they don't pay the fee. And the statute is broad. It's any law enforcement agency. So if it's somebody, say they have a particular beef with Hopkins, I'm just picking on Hopkins, and so they don't like Hopkins. They don't want their firearms to go to Hopkins because they don't like Hopkins. They can go to Minnetonka. You can transfer them to anywhere. And it also makes sense, especially when you think about Minnesota. Like, so I have, say I have a hunting cabin in Beltrami County. Well, we don't want me driving up to Beltrami County, getting my firearms and driving them all the way back down here, right? We want me to then give them to Beltrami County and keep them there, as opposed to me driving around the state with my firearms when I'm not allowed to have them, right? So that also makes sense. A relative may only be the one who takes those firearms if it is an antique firearm or curio as defined by federal law. And of course, then that relative has to be legally able to possess and not live with the respondent. And as I said, there could be a request for an extension. We actually have one that's moving forward right now in Hennepin County. It's basically, you apply like you're applying for a new one. And the statute tells us that you need to do so within 3 months before the expiration. The court still has to find by clear and convincing evidence that they continue to be a danger to themselves or others, or significant danger. It can last for 6 months to a year. So. If somebody possesses while there is an extreme risk protection order in place, it is a misdemeanor. And then they are prohibited from possessing. If they were to be convicted of that, they would be prohibited from possessing at all for 5 years. It is, in addition, though, been added to the statute, which is 624.713, that prohibits a variety of folks from being able to possess. It's a whole bunch of big list of things that can make it so that somebody is unable to possess. And ERPO has been added to that list. If you are ineligible to possess a firearm under that statute, it also means you're ineligible to possess ammunition, which is sometimes a surprise to folks because the ERPO statute doesn't talk at all about ammunition, but it gets scooped in under this part of our statute. It's also a gross misdemeanor if you possess and you are ineligible under the statute. So 2 different spots where somebody could be charged with a crime if they possess. It also voids any permits to carry, any transferee permits, or any permits to purchase. Now, it's also a gross misdemeanor if you petition and it's materially false with intent to harass, abuse, or threaten, so let's not do that. Not a good thing. All right. Has anybody been charged? Not to my knowledge, no. I don't know anybody who's been charged with violating it either yet. But it's still a very brand new statute. Yeah.
I have a question. After the ERPO is initiated and completed, is there any follow-up for whatever the situation was, any social service contact or anything like that?
I mean, me, if someone has filed with me, I had my first filing was a mom filing on behalf of her son, and so her and I did have some follow-up. If someone does file with me, like not so much social services, but I do guide them through the court process. So like tomorrow I have someone who has an initial hearing. If that goes to evidentiary, I talk them through how to upload evidence, any of their statements, like preparing their statements, things like that. So, but yeah, I do, I have a lot of resources. I share them at DASC as well.
But outside of that,
Yeah,
no. There is,
And that's part of the gap, right?
Yeah, it's a gap.
Someone has mental health and they may go to like HCMC or North Memorial for a small amount of time, and then if they don't end up going through the commitment process, they mean they're going to go home. So
yeah. And it's a gap, and it's one of the things we're trying. Those of us who do these are having lots of conversations about, because you hit the extension phase and you're like, especially if law enforcement filed, if law enforcement hasn't had contact with that respondent, you don't have any information. I mean, you can't file for an extension. Yeah, the allegations last year were super scary, but what do? You call them up and you say, hey, are you better? I mean, like, what's your... So yeah, and they're just, and then, what's the financials of being able to provide that kind of follow-up is also just not there right now. But yeah, I hear you. It's a gap for sure. Yeah.
Oh, she has
Oh,
the mic,
sorry. My bad.
Couple questions. One is, could I see the list one more time of who can file? One of my concerns, so I work with a lot of young parents who are not married, so they're not a spouse or former spouse, but there is definitely domestic violence going on and a big threat.
Yeah.
So one of my questions are like significant, I guess, does this mean that in that situation, if they're co-parenting a child together and they've never been married, that they can't file?
No, not necessarily.
Okay,
So the question's going to be, are they in a significant sexual or romantic relationship?
Perfect. That's that fifth one.
Yeah.
Okay, good. I was like, wait, here we are.
Yeah.
That's the first. The second question is the level of evidence. You mentioned the level of evidence needed for that extension, right?
Yep, it's clear and convincing is the standard after an evidentiary hearing. Yeah.
Okay. So in order to get the emergency one,
Yep.
how much do we just believe the people that are saying this? Like,
Yep.
I believe them, just
Yep.
to be clear, but like, if somebody comes to me and they're like,
Yeah.
this person is threatening violence.
Yeah.
And I'm really worried.
Yeah.
And they've brandished a gun at me, but there's no
Yeah.
picture, there's no
Yep.
text,
Yep.
it's just been all verbal.
Yep.
Can we still do it?
Yes, you can. It's at the ex parte stage, it's probable cause. And the court is required to read the petition and to believe everything that's in the petition, unless there's something that gives them a whole lot of reason not to, like they're saying that I need to get an ERPO against the Mars genie, or you know what I mean? So, but otherwise, like, the court is to read the petition, believe everything that's in it, and then say to itself, if I believe all these things, do I have probable cause to issue the extreme risk protection order? Okay? Yeah.
I can see where it'd be helpful for a teenager, to have knowledge of an ERPO. Just would it be possible for a teenager to apply for an ERPO, or what would the process be? Kids see a lot.
Yeah, they absolutely
in the home,
do.
And they feel a lot, and I can see some information like this really being helpful to a high school class.
Yeah.
For example, throughout the state of Minnesota, kids know, kids see.
Yep, they do.
And so what would be a process for a teenager
Yeah.
to apply?
I think the problem for a teenager is if they're under the age of 18, they're a minor, and their ability to file legal actions on their own are significantly inhibited. So if they were 18 or over, then they would be able to file on their own as long as they meet the family or household member definition. Otherwise, for anybody else, I would say I'd reach out to law enforcement, or otherwise as a teenager to reach out to a trusted adult and have those conversations and figure out who makes the most sense to go and talk to. Yeah, for sure.
I'm just curious how quickly the courts turn around the emergency orders.
Oh, yeah. Really good question. Fast.
I got one in 30 minutes last Thursday.
Yeah.
Yeah.
Yeah. We try not to torment the court by filing at 4 o'clock in the afternoon because we feel really bad. But I try to, like, if I'm going to make it in there by 3:30. But yeah, the court these are super high priority. They're even arguably a higher priority than orders for protection. And there's not as many of them, in the grand scheme of things. So the court is super fast at being able to get these processed. And I will also say that there is for law enforcement, Hennepin County has an after-hours process for the Hennepin County courts that law enforcement has access to. So don't think, oh, it's, Saturday, there's nothing I can do about it. You may not be able to file, but law enforcement may be able to. So it's really important to still reach out to law enforcement if it's after court hours.
Yeah, that was going to be my second question is what kind of willingness for cooperation are you seeing from law enforcement and their ability to manage these firearms that are being handed over?
Yeah, I mean, in general, law enforcement, I think, has been really supportive. Yeah, in general, law enforcement's been really supportive. And I think about one of my law enforcement departments, they ended up taking 600 pounds of ammunition off a guy, and 93 firearms. And they're, when we talk about it, they're like, yes, and they're in our storage unit. It's a thing. They're stressed about it, and they did it, and they're not going to stop doing it. And they actually did, and they're seeking to extend it because the respondent is still not doing very well. So I have seen a lot of support. And Minneapolis even has filed, oh my gosh, I've lost track now, over 10 so far this year. Minneapolis is filing, folks were like, Minneapolis will never file. They're right on top of it, and they've got 3 attorneys who are responsible, and they are taking care of it. So, definitely it's worth having the conversation with your law enforcement if there's a concern.
Okay, so when you say Minneapolis, Minneapolis what? Minneapolis Police Department? Okay, so sometimes they go directly to Minneapolis Police Department and not through your office?
Most of the time, actually. Our office only files in very, very, very rare occasions. I'm a backup. But yeah, mostly it's happening through our city PD who are filing. Excuse me, sorry. And it's Minneapolis City Attorney's offices filing on their behalf, but it's coming through MPD. Mm-hmm. Oh,
okay, so Minneapolis City Attorney's Office actually does the paperwork,
yeah,
but it's started at the Minneapolis Police Department?
Correct.
Mm-hmm. Okay. Yeah. So who actually completes the petitions, in your office? Is that something, is that what you do, pull together all the evidence?
Yeah.
Depends on the situation.
Depends on what's going on, but yeah.
Between the two of you? Okay, and then it sounds like judges are turning it around real quickly. Mm-hmm. And then, what, does it go from the judge then to what's the next step? Does it go to the police department? Because it sounds like you have to reach out,
Yep.
You contact the person who's at issue here and you give them the choice. Do you want to turn over, or do they just show up with a warrant? No, I think it said they actually give people the option before they come in with a warrant. Yeah. So so the process is so if it is an agency who is petitioning, then the signed order comes back to, so if it's me, so say it's me petitioning, it's going to come back to me. I'm going to figure out who is, I will know, but I will then I will reach out to the police department that is primary 911 for where the respondent lives. I will then send it to that police department, and then they will go out and serve it. If it's a family or household member that is filing, then the court is going to send it to the law enforcement agency that's primary 911 for the respondent.
and then law enforcement will serve. Sometimes the service part for law enforcement does take a little while depending on what is going on. If we have somebody who is really scary, there's a lot of preparation law enforcement needs to go through to make sure that they are safe and the respondent is safe and the neighbors are safe, right? So in trying to figure out what's the best way to make that happen. So it doesn't always just, they don't get it and then like beeline out. The other thing that's been really interesting is the service is falling to our police. Police in Minnesota don't serve civil process outside of this. So it has been a brand new process that they have had to learn. I was helping an officer actually just the other day on service, and I'm like, okay, don't forget, I need you to do the certificate of service. And he's like, what's that? And I'm like, I will send it to you. And then what do I do with it? Then I need you to file it in Odyssey. Okay, I know what that is, right? So it's been a lot of, definitely a big learning curve for everybody.
So would you say most of what you're doing is in the city of Minneapolis? So you're working with Minneapolis law enforcement?
I mean, I do work with Minneapolis, but I do a lot of work with all of our suburbs too.
So it's not predominantly Minneapolis?
No, I mean, they end up right now they file the most, but they also have the most people, right? But yeah, we were just, where were we? We were just in, oh my goodness, my brain just.
In my place. South Lake.
Yeah, we were in South Lake. We did a training for South Lake. I've been out and helped Deep Haven file. I mean, we've been in some tiny cities in Hennepin County.
Yeah, it's like Mound and
yeah, we've been out to talk to New Hope. I've been out and talked to Minnetonka and Hopkins, and yeah. So Brooklyn Park has a specific officer whose responsibility it is to manage their ERPOs. So does Minnetonka, and so does Edina. So yeah, it's been a really good, I've been very, I was coming in, I didn't know what it would look like. I've been very pleasantly surprised and just really proud of all of our partners in Hennepin County and how just they've embraced this as a tool that's super helpful.
I have two questions. They are intertwined. One is out of the ERPOs that have been filed, have you done any analysis how many finally ended up 30% of them are because of mental health issues? And in those cases, when the authority is handed over to a mental health specialist, that now their words will be on top of everything because they are going to assess, and until they are going to sign off that the person is safe, it will not be given because they are the specialists. They know how to analyze and see that the person is out of the suicidal mode or aggression mode. So is it something one is about the data, how many are mental health issues, and the other is how these cases somehow goes finally those which are mental health issues, they hand it over to the mental health providers and their sign off is important before the weapons or firearms given back to them.
I mean, the majority would say are mental health. But I mean, I think if I'm hearing your question right, are you asking, so if it's for mental health, if they're getting put into treatment, so we don't know, honestly. So this is a lot of, unless I work with the person and they tell me, we don't know if they're going into inpatient, and there isn't, unfortunately, like we said before, that's not that follow along. There is that missing piece there.
The thing is that there will be a disconnect. If we just go with the 10-year, 14 days of order or long-term order, but the root cause is mental health, and we are not taking that person back to where now it should belong. Now, when we were blank, that was a different thing. Now we know that this person has never seen a mental health doctor, or he is going to someone, but now it's time that that referral is important, and now we should send it. Otherwise, there will be a disconnect. We can give the arms back without addressing the main issue. And neither the attorneys, now the police is trained to see whether it is PTSD, it is schizophrenia, what is causing. So I think that is important. for a kind of a, before giving the firearms back to the person. So I don't know if there is any, the law gives you that kind of a thing, or we still have that gap.
I mean, the statute only allows us to take firearms temporarily and only at a year at a time. I hear what you're saying very much. And unless somebody ends up committed involuntarily, because then that triggers, again, under that statute I talked about that made people ineligible to possess, that would trigger a lifetime prohibition unless they get their rights restored. But it's a huge gap, and this is a piece that can help fill a small part of that gap. It does not solve the issue that you're identifying, and we agree. It also, what do you do if you have somebody who has their philosophy on life is a violent philosophy? Like, that's not going to change in a year. It's unlikely. What do you do? And we're having some, we're trying to have we have those conversations amongst the professionals that I work with in this area, and we don't have super great answers either. Like, we're struggling around what are those answers? Because you're right, somebody who's schizophrenic is going to be schizophrenic at the end of the year, right? I hear you, and this is a tool that doesn't do super great for that particular situation.
I'm thinking of a frightened mother, a frightened wife, or a frightened child. Who should they call? Should they call the police, or who?
Yeah, they should call the police.
Okay.
100%. All right, so some other stuff to know about the ERPO statute. The statute does have some requirements for mental health professionals as defined in statute. It creates a statutory duty to warn for them. So mental health professionals, if they believe their client is a serious threat of a physical violent behavior, or they're a significant risk of suicide by possessing a firearm, they have to call the sheriff's office in the county where their client resides and make a recommendation to the sheriff's office regarding the client's fitness to possess a firearm. And I highlight the fact it's the sheriff's office because mental health professionals' other duty to warns, they call the law enforcement department closest to the client, not the sheriff's office. So it's a different spot they have to call. Health records and other health information can be protected from public disclosure, needs to be filed properly, but it can be provided to law enforcement. But I do point out to folks the information in the petition is public information, and it is very public information. Some stuff in courts you are unable to see if you're like at home and you log in and you go and you look at MinCro, which is the court's record system, that you can check out stuff at home. Like orders of protection, harassment, restraining orders, you cannot see from home, but ERPOs are very public. You can see them from home. So keeping that in mind, the petition itself is going to be very public. The legislation has a bunch of stuff in there about sealing. Sorry, Bonnie. And the Supreme Court said, nice try. The Supreme Court said that they said two things. They said, one is sealing at the Minnesota Supreme, like the courts, that means something very specific. It's a term of art. And to them, if you seal something, it means nobody can see it, including like the vast majority of judges. It's only like the higher echelons of the court administration that can see it. So they said, we're not going to seal it because that means law enforcement can't see it, and it means we can't submit it to NICS. And then they also said, hey, you legislature, stop telling us what to do with our files. That's a separation of powers issue. And they said, we're going to do what we want. They said that if somebody motions the court and asks for something to be marked as confidential, the judge with their discretion can decide to do so. But otherwise, we're not doing those things. And I point that out because the statute has all this language in it. And I literally just talked to a lawyer today who was like, well, I just can't believe that this is public. And I'm like, yeah, well, okay. Well, the statute says, I'm like, I know, you need to go read this Supreme Court order that says something else. So that's why I pointed out, because the statute says one thing, but what's happening because of the Supreme Court order is different. And things that folks should really think about when they're trying to decide whether an ERPO makes sense for their family. Law enforcement will be involved. There is no way to get around this. I mean, Bridget and I make jokes about how they should let us go and like serve orders and, you know, do the warrant, but they're not going to let us do that. Liability, something, blah, blah, I don't know. But anyway, law enforcement will be involved. And so that's really important to think about depending on the communities, right? I mean, we have different communities here in Minnesota where law enforcement showing up at their door is a terrifying prospect for a whole bunch of reasons. So it's really important to be honest about the fact law enforcement will be involved. And it's more than likely going to be the respondent's local police department, and they may have particular opinions or feelings about that local police department. So keeping all that in mind, and that there is that possibility of a search warrant. And for some folks, because law enforcement will be involved, that makes this not an option for them because of their community. And you just got to be honest about it. It's also important to think about, can the respondent legally possess? Because if they can't and they have firearms, well, there's a very easy and quick, at least gross misdemeanor, possibly a felony, depending on why they're not able to possess. And so that could lead to criminal charges. And so again, things to think about, you know, and I definitely had that conversation a while ago with an attorney who was thinking about filing on behalf of their family law, with their family law client. But he had been involuntarily committed at some point, which means he's not legally able to possess. And the wife, or the estranged wife, was not ready for him to she didn't want him to get charged with anything. She just wanted the guns not there. So it was a thing to think through. And I have legislation to try to deal with this too. But, but it's important things to think about, right? All right, Bridget's going to talk about firearm storage.
In addition, I know Maggie said when she opened, you know, there's the one thing you can do, which is extreme risk protection order. So there's another thing you can do. We talked about secure storage. So currently in Minnesota, there is not a law that makes anyone secure their firearms as long as there's no children present. So there is a negligent storage law where you must have your firearm, or let me say it the other way. You can't have your firearm that is loaded out and unsecured while children are present. So there's a couple things you can do about secure storage. So there's a cable lock. The cable lock kind of looks like a bike lock. I table outside of my job here, and a lot of people will ask me if they can take bike locks. And then it's a good education where, like, no, this is a firearm lock. So this goes through the barrel, and it comes with a key. They're free. Most places, Hennepin County libraries have them.
Most police departments.
Most police departments have them.
Bridget has them.
I have them at my office. If you see a Mom's Demand table or a Be Smart table, they have them. You probably can contact the Department of Public Safety and they will mail you one. Yeah. And then there's a lockbox or gun safe. There's an electronic lockbox or a biometric safe as well. Also, like, kind of trusted individual hold. I use personal experiences a lot of times. So my uncle has dementia and my cousin just has his firearms now. So that's another option if you don't want to have to go through an extreme risk protection order. Like, obviously he can't go buy any more firearms. He can't drive anymore. This was the safest and, like, just respectful plan to do. So one other thing is separating ammunition from a firearm. Raina said put it in a freezer. So I have done community gun violence prevention for a long time, and I had never heard it. So I met Raina, and it gives you a blast of cold air. So when we think of time and space, people that are have suicidal thoughts with a firearm, it is like split seconds. So when you get that blast of cold air, it kind of changes your mind. Is kind of how we present it.
It just slows people down.
Yeah.
Oh, sorry.
No, it's okay.
Not
I can do
staying on
both.
my.
I got two. So these are just some options for a gun safe. The full-size gun safe is obviously, like, your best option. My dad actually has one, which I didn't even know they do. It has a code and a lock, so it's double. So if someone gets your key, you also need the passcode. There are some very expensive ones that require a fingerprint as well. So you can do a lockbox or a locker, the console for vehicle, gun safe. And then you can do gun safe, so this, or gun case, so this would be like transporting firearms. A trigger lock as well for a single weapon. You're not supposed to use this with a loaded gun. And then the cable lock, this last one, that looks like the bike lock. Those are the free ones. So we just talked about modeling responsible behavior. It's always the adult's responsibility to prevent unauthorized access to guns, so it's not a child's responsibility. We always tell people also to teach parents to make it part of their normal conversation with children. So keeping it simple, like if you see a gun, don't touch it, tell an adult right away. Don't ever assume that a child doesn't know where a gun is stored. I am blanking on the name, but it was somewhere in between here and Duluth where the dad and his friend were playing video games in his basement, and I believe their son was 3 years old, and he was in their bedroom like watching a movie, and he shot and killed himself. So your kids very much know, any children know. They're always watching you, they're listening to you, they're curious. I joke that like my youngest daughter will scale our closet shelves. You know, she hangs from the oven door, like she is a very wild child. So don't ever assume that they don't know where the gun is. Discussing with parents so that children, even as young as 2, can pull a firearm. I told Raina I'm going to add this to my spiel about safe storage. Pennsylvania just had a case where a guy was cleaning his gun. It was loaded, which again, you should never do if you go and if you hunt or know anyone that hunts. When you clean your gun, it needs completely empty. And his dog jumped on the bed and shot him. This is in Pennsylvania. So can't remember what city. So yes, a dog can happen now. And another thing is children do not know the difference between a toy gun and a loaded firearm. My children have never seen a firearm. So if, you know, they're at someone's house, they're not going to know, hey, is this a water gun? Is this a bubble gum or gun? Or is this a shotgun? So teaching parents to ask about unsecured guns. So 4.6 million U.S. children are living in a household with at least one loaded, unlocked gun. There are more guns in this country than there are people. And when I say people, I mean 0 to 110. So make it, you know, telling people to make it part of their general safety conversation. So like me, I have 2 very large dogs. So when my children are inviting other children over, I say like, hey, I have 2 large dogs. They're very nice. They're very friendly. Is that okay? Are there food allergies? And also I say like, we don't own firearms in our home. I do the same thing when I'm asking, you know, my children are going to somewhere else's home. I ask like, oh, like for example, I'll say like, oh, well, you know, my oldest needs a booster seat. I'll hand you the booster seat, and then asking if you have firearms, and if you do, like, are they secured? These conversations, I always am, you know, non-judgmental about it, like even with the extreme risk protection order. I'm very open. My father hunted, my brother did. My dad owns firearms, making it not a judgmental conversation and more of like an educational conversation. I always encourage email or texting, you know, sometimes confrontation, if it feels like confrontation, even though it shouldn't, can always be a little awkward. So texting is a great way to do that as well. I screwed up last time. And then recognizing the role of guns in suicide. So most people who attempt suicide do not die unless they use a gun. Secure firearm storage is associated with a decreased risk of child firearm suicide. As children get older, it's important to think differently about safe storage. So a key lock, you know, probably works just fine if your kids are in elementary school, but it might not be the best option for when like your child is in middle school or high school, especially, you know, you think like one bad day when you're 13 can really like lead you to make a decision that, you know, could affect your life, or, you know, something that you would regret if you survived that. So upgrading to a code safe or a fingerprint safe as well. All right, so we talked about how to refer people to me. If there is a family or household member willing to file, we think of like not an emergency, life-threatening situation. You can refer them to me. I help them through the process. Before we start filing, I go over the law. I go over the pros and cons of it, letting them know that law enforcement will be involved. There will be a warrant, or could be a warrant. Shouldn't say will be a warrant, depending on the situation. Does the respondent live in Hennepin County? So unfortunately, if you live in Hennepin County, but your dad, for example, lives in Ramsey County, you have to file where the respondent lives. That doesn't mean I won't help you walk through the petition. I can help you type the petition. You just have to take it and then file it online with wherever county they live. Like I said, kind of the emergency, who can file faster at that moment? If it's an emergency situation, law enforcement can file because they can get the search warrant, or then they can respond and hold the firearms and then do the extreme risk protection order. So, how to refer? I am at the Domestic Abuse Service Center. I also like to say if someone is not experiencing domestic abuse, like if it's mental health, if you have any questions about safe storage too, you can give me a call. As well, it's open. It's just how the Domestic Abuse Service Center is set up. We have front desk staff, so you can call and then they can have them get a hold to me, or they can say, well, Bridget's out this afternoon, she'll be back tomorrow, telling you to go in law enforcement or come back. So I encourage calling. I am also there a couple days a week. It just kind of depends on the day. So I do take walk-ins. And if someone does walk in, our front desk staff will put them in a private room and then they can call me. And then this is the direct number to the Domestic Abuse Service Center. So, and then these are just some more resources. So the Judicial Branch website, that's how you get the forms for the ERPO. This is the voluntary firearm storage. It's just like a nice little map of where people can store their firearms. And then this is the Domestic Abuse Service Center again.
And here's our contact information and our fancy email address that you can get us at. And then the phone number is the Domestic Abuse Service Center, because that's the easiest way to get a hold of us. So, all right, we have a few more minutes. Are there any other questions? You guys have had great questions.
I do have a question, because this may be another area for some legislation. Recently, there was the child that got a hold of a firearm in a home where there were like 13 guns and only one of them was secured.
Oh, yeah.
And my understanding is the parents were only charged by summons with a gross misdemeanor. So if you negligently store your firearm and your child or some other child accesses it and they harm themselves or someone else, is that literally the maximum? Because I have some ideas, including the fact that if you don't safely store your firearm and it is used to harm or kill another person, that you're just banned from owning firearms forever. But it seems weird to me that it was only a gross misdemeanor, and so I'm wondering if that's part of the safe storage. Senator Gustafson has been trying to pass, I think would include safe storage requirements, including homes that don't have children, but I'm concerned about the penalty part.
So I think it's all like what happened. I know which story you're talking about, and I can't remember the outcome. But I've seen someone have a gun go off while the children were present, and they got charged with something else too. They got charged with negligent storage, but they also got charged with like discharging a firearm in a municipality,
limits, yeah,
city
so
limits.
it's
So it depends on each situation. Yeah, which is a felony.
That's a felony. Yeah, but the
Yes.
right.
Right,
yeah.
no, I know. And the thing is, what I'm seeing, like with safe storages too, is with the children is, it's hard to kind of prove. Like I would, me doing this more stuff, I would like to see more like knowledge of it as well too, so.
And I think I'd have to think about it, Bonnie. I need to look. I haven't. It's a really good question. I just haven't. That's not a thing I've looked at.
Yeah.
So yeah, but I think it's a thing that I think should be considered and thought about, and then we need to figure out how if Minnesota law addresses that well or not.
Mm-hmm.
That's a good
But
question.
I would like to have a talk, about safe storage. I'll talk about it all day too, anytime.
My question is about the mental health professionals, where you talked about like they should warn about any of those kind of situations. So when you are saying warning, they warn and they report it to the sheriff, I'm assuming we are not talking about they don't have the right to file ERPO. It is a separate route. It is more like a giving warning involving police, but it is not they cannot file ERPO. Is that right?
The mental health professionals?
The mental health professionals?
Yeah, they can't file themselves.
They cannot?
No. Nope, so they call the sheriff and do their duty to warn.
So yeah, so here when I see, I mean, just my question sometimes coming from mental health, because I'm like surrounded by psychiatrists in my family, and I see them very helpless when we say that when they warn and they send anyone, and the police goes to the patient, they are dependent on the assessment of the police officers who are not trained psychiatrists. So it is something that they ask questions, hey, how are you doing? Everything is okay, and yeah, I found the guy is okay. But that is not something which is being done by a professional psychiatrist. So when a medical health professional warns, many times their warnings go unattended because the people who are doing the assessment, their tools are different than the tools of the mental health providers. And sometimes they misjudge the situation because based upon their own understanding, because this is not what they are trained for. So how to make it effective, like how to give them more handles to the mental health providers to make it happen?
Like being able to file?
Either they should be able to file, or there should be a different process to assess, because it is difficult for the police officer. We are asking them to do something which they are not trained for.
Yeah. And I can speak to, the first part of your question. I don't know about the rules changing mental health professionals. However, what police departments are doing in Hennepin County is they are having embedded social workers, and they are filling that gap with the mental health piece, and they are doing a really, really, really good job. So what happens with those is, like, if someone's calling 911, we have Hennepin County COPE too, and some people, if they know about it, they can call COPE, and mental health professionals should, and I'm assuming they do know Hennepin County COPE. But what is happening is, if someone calls 911 and they're having a mental health emergency, some of the embedded social workers are able to go out with the police officers to homes, and there's not a ton of them. I'm really hoping we get more funding for them. Right now I think like Brooklyn Park, St. Louis Park, Minneapolis, Crystal, and New Hope might have them. It's some of the first ring suburbs, and like St. Paul has them. So
I know Eden Prairie has one.
And Eden Prairie has
sure, I
one
know
too.
that.
Yeah, so that's expanding out, which is great. Yeah.
This is more to the legislator who is here, but I found the article about the incident in Roosevelt, Minnesota, and it is actually way worse than was just stated. I mean, there was a number of children in the home. The police found 34 other weapons in the house, the majority, except maybe one or two, which were loaded, and they were not in any kind of lock boxes or secured in any way. Has there been much my guess is that it just can't get a lot of traction, but has there been much movement in Minnesota about requiring some kind of safety regulations about the storage of weapons?
Yeah.
Funny you should say. So my colleague Senator Gustafson has carried the safe storage bill in 24 and 25, I believe. She came so close to getting bipartisan support for it, but fell short. There were a couple of people who were thinking they were going to support it and vote for it, and then on the other side of the aisle, and then their colleagues and others began actually threatening them, is my understanding. Nice people. The problem with safe storage is we don't have the votes right now. And so, especially with the House being equally divided, anything that we do or try to do in 2026 is going to have bipartisan support. Now, I think in the Senate there are things we can do, but if we can't get it passed in the House, nothing will happen. But just know that there have been a lot of efforts to try and get safe storage. I have the lost and stolen firearm bill. Believe it or not, if your firearm is lost or stolen, you are not required to report it to law enforcement. Seems like that would be a good thing to have to do. So we are doing those among other things. And I would say keep showing up. If you can come down to the Capitol, find out when the gun violence prevention lobby days are, come down to the Capitol. Certainly talk to your own legislators, but the big thing is in 2026 we need to start electing gun violence prevention legislators. And I am going to suggest that maybe it's time for us to be single issue voters on gun violence prevention.
I'm curious, what are the major arguments against safe storage? What is the logic there?
Do not ask me to explain the logic in somebody else's brain. There are people who will tell you, hey, I live out in rural Minnesota and, you know, something happens. It could be 20 minutes before law enforcement gets there. And if I have to unlock my gun, blah, 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 blah. We all know it takes a couple of seconds to access your gun. And there are just some people who say, you're infringing on my right as a lawful gun owner. I can't explain it beyond that.
All right. Well, thank you, everybody. You were great. You had wonderful, wonderful questions. Thank you so very much. And we're here to support you guys, so feel free to reach out.